Hey everyone, Harry here to talk about the indictment of Judge Hannah Dugan, a state court judge in Wisconsin, on charges having to do with allegedly helping conceal and preventing the arrest of a man who was in her courtroom to answer criminal state charges. But the 6 federal agents were on the scene to arrest and deport him for being unlawfully in the country. All right. We talked about this when it happened. It was fairly stunning that, in particular, they arrest and cuff the judge at work. It's hugely overbearing. They obviously wanted to make an example of her as part and parcel of their, chest thumping pushback against states. And there are many who don't want to cooperate with the very aggressive deportation efforts by the administration, which, by the way, as with this guy, seems to be focused mainly on, or the low-hanging fruit they've gotten to date have been people whose crime or offense is just not having their immigration status fully proper and everything stitched up, not the sort of murderers and rapists and rampagers that Trump is always touting. Anyway, Dugan has such a person in her courtroom. He's doesn't have a criminal record, although the charges are pretty serious, domestic violence. And one of the problems with the way they've done it here is other defendants may not show up to answer criminal cases if they think they're going to be collared and sent away, deported out of the country. Okay, but this happens. They arrest her in a very ham-handed way, and now follows the indictment pretty much as night from day. It happens occasionally. I've experienced it, or my office has, once or twice, where a grand jury balks and doesn't return an indictment. There are already problems here on the face of the allegations, and you could have. It's possible this could have been a case in which, or maybe even it did, the grand jury pushed back some, but as was very predictable, they return the indictment. And the indictment has 2 different criminal counts. The first is a charge under Section 1071 that basically she knowingly concealed Ruiz. That is, she, as the indictment charges, which is statutory language, she knowingly concealed him with the knowledge that there was an arrest there, so as to prevent the discovery and arrest. Let me just start there. That's really the heart of the charge, and it's going to be a real contested characterization at trial. She does tell him to leave through the jury door. There's an interesting sort of discrepancy. The affidavit itself suggested that she had ushered Ruiz and his attorney out the jury door, which is the alternative exit from the courtroom. The indictment does not say that, but it rather says she directs them through the jury door, says take that exit. That'll be interesting and a matter of real ferocious cross-examination of the agent at trial. Well, which was it? Anyway, the big point here is, and we talked about this when she was charged, the hallway that she told Ruiz to leave from led directly into the same place where the agents were waiting. One agent was already waiting there, and the other 5 were out talking to the chief judge about, at her insistence, how should this be handled? This is a whole, situation where the feds, to her surprise, descend on her. So there's an agent there, follows them to the elevator, goes down with them. By then, the other 5 have assembled. They go to arrest him. He runs, but only the length of the building. They arrest him. End of story. So is that going to be, are they going to be able to prove beyond a reasonable doubt that she knowingly was trying to prevent his arrest? There's a perfectly plausible other scenario, in some ways more, which is she didn't want to make a scene in her courtroom and immediately outside her courtroom. So she said, go this way. She didn't expect, much less, intend that he would elude arrest. She was sending him, part of this will depend on the layout of the courtroom, et cetera, but she was basically sending him back to the public space where the agents could converge on him. It's just not in her courtroom. So that is very possible, the kind of testimony from her that the United States will encounter at trial, and how they're going to prove their version of it beyond a reasonable doubt, to me, is a really significant obstacle that, if they were strictly applying the principles of federal prosecution, which it's as probable you can convict on every element, they shouldn't and wouldn't have brought a case, and a supervisor would have prevented it. This one obviously is part of this national priority and, was pushed through by Bondi herself, who made these completely intemperate, inappropriate comments at the indictment stage, calling her deranged, calling judges like her deranged, and other things that are unbelievably beyond the pale for the Attorney General of the United States to say about a defendant who's presumed innocent until proven guilty. Okay, so that's going to be the core factual dispute, and there's already going to be sort of sympathy there. Then in addition, the second count has these different, it's under the obstruction part of the federal code, and it just takes these, details of what was obviously a confrontational, fast-moving, what the hell's going on here, involving the judge, involving the agents, involving the chief judge, and gives them a sort of sinister turn, that she confronted members of the force and falsely told them they needed a judicial warrant. We don't know what the words were. It's true, an administrative warrant can suffice. There'd be no reason for her necessarily to know that one way or another, or she might have been saying, here's what you need in my courtroom. Other things like that. We have now directing him to exit through a non-public jury door. That's what we've just talked about. It's the alternative exit. Advising counsel that the next hearing could be by Zoom. Okay, you can see maybe what's going on there is, I don't want you to come to court and therefore face this personal danger. It's really quite a, I think, hard road to hoe for the United States to make that action. You can have Zoom hearings. People have them all the time. And I think there's just got to be a difference in the law between not going to efforts to permit him to be a sitting duck in court that the agents could just pick up, and doing what the law permits her to do, which is to hold a Zoom hearing, even if that's part of the reason she's doing it. So I think what you see from the indictment, now that they've had to flesh it out, is an overall effort to take a debatable confrontation, and by the way, a predictable one, because they're storming in 6 federal agents where she's conducting her regular court business, and try to make it out as some nasty anti-federal, the equivalent of sort of harboring someone in your basement to keep them from being arrested and the like, which would be a crime. But these are acts that are totally susceptible to the interpretation. I'm not trying to keep you from arresting them. I'm trying to keep you from totally disrupting my courtroom. And second, construing acts that she's perfectly entitled to do, like a Zoom hearing, and trying to make them make a federal case out of it, as it were. I think this is an uphill battle for the feds in court. I think it's really an unfortunate case to have brought, and definitely the ancillary treatment, the terrible public comments about her, which could cause there to be complaints filed against Bondi, and the arrest and cuffing, at the workplace of a 60-some-year-old, I think Judge Dugan is, completely unnecessary. This is a law enforcement agency run amok. So we'll see what happens at trial. She's not working until then. She's suspended. That also sort of follows as a matter of course. My prediction here is she will not be convicted on these charges anyway. You might think of maybe a face-saving plea by the United States to a very small sort of misdemeanor. But I think at this point, Dugan may be wanting to go and vindicate herself at trial, and that will be, if it happens, real egg on the face of the feds. It's going to take a while. It's the federal system. But I think this is a case that history will record as a bad instance of overreach and a prosecution that is eventually going to embarrass the Department of Justice. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.